Welcome to this in-depth session on the changing quality of polity questions in the UPSC Prelims from 2020 to 2025. The nature of questions has undergone a major transformation from simple, factual, article-based questions to deeper, conceptual, interpretational, administrative, and judicial questions. In this video, we are not just looking at the number of questions or the topics, but the quality of questioning, how UPSC frames its statements, how it hides traps inside options, how it tests governance understanding, and how it mixes constitutional reality with administrative functioning. We will use actual previous year questions with full statements as evidence for each trend. So let's begin. In this session, I will cover five major things. First, the year-wise evolution of polity from 2020 to 2025. Second, a detailed explanation of what actually changed, not just topics, but the quality of questions. Third, I will show complete previous year questions exactly as UPSC asked them so that I can substantiate each pattern. Fourth, you will get a clear blueprint for how to prepare polity for 2026 based on these patterns. And fifth, I will show you the elimination logic because this is now the most important skill for polity. The biggest shift to understand is this: UPSC is no longer testing your ability to memorize articles, schedules, definitions, etc. from Laxmikanth. Instead, UPSC wants to see whether you understand how the constitution operates in real life, be it in administration, governance, federal structure, and judicial interpretation. From 2020 onwards, UPSC it slowly moved away from predictable polity questions. By 2023, the focus was strongly judicial, especially Article 21. And in 2025, polity became heavily intertwined with administrative functioning and who has authority questions. This is the most important shift that an aspirant needs to understand. Now, to build a meaningful analysis here, I have used a complete data set of 2020 to 2025 polity questions from the official PYQ file. Each question was examined and categorized. Like, is it purely factual? Does it test a concept? Does it test administrative functioning? Or does it involve judicial interpretation? Is it a high level multi statement trap? So, things like these were examined and categorized. And after comparing the shift in proportions, we get a very accurate picture of what UPSC is moving towards. So, the year 2020, it marked the clear beginning of conceptual clarity. 2021, we saw extremely tricky statement based questions, options that look the same, but only one is correct. In 2022, polity was dominated by real life administration. For example, top questions from schedules, tribal governance, writs, etc. Then in 2023, the pattern leaned heavily towards judicial interpretations, focusing particularly on Article 21. 2024 was unpredictable. Constitutional history, writs, judiciary, and tricky logic. Again, the year 2025, it confirmed UPSC's new direction towards functional governance and which authority does what questions. Now, let us begin with 2020 in detail, which was the first big shift. So, here, this question on Gandhism and Marxism. First of all, it is not from your normal Lakshmikant, it is from the political philosophy. Here, the UPSC wants to test whether aspirants understand the foundational ideas that shape political institutions. You can also notice how the options are tricky. Class struggle, it is associated with Marxism. Abolition of private property is Marxist. Economic determinism is Marxist. Only the idea of a stateless society is shared between Gandhi and Marx. So, here, this question tells us clearly that polity is no longer just Lakshmikant, it includes deeper conceptual understanding. Again, this 2025 question it marks a dramatic leap in polity quality. UPSC is no longer asking what is IED or what is DRI. It is asking who controls these bodies. And more importantly, UPSC is testing whether aspirants know the exact administrative structure or not. The trap that has been put here, it was deliberate. UPSC placed Enforcement Directorate under Ministry of Home Affairs, which pretty much looks believable but is completely wrong because ED works under Department of Revenue under the Ministry of Finance. So this style of questioning is now becoming a standard. It requires you all to go beyond textbooks and understand functional governance, how ministries and directorates are actually structured. This is what UPSC is testing. From 2021 onwards, UPSC Prelims Polity saw a rise in multi-statement, highly conceptual and trap-oriented questions. The question shown here is a perfect example. All four statements look correct, all seem sophisticated, all can be justified superficially. But only one matches the actual political science definition of a state: a community of persons occupying a definite territory, independent of external control, and possessing an organized government. This question tests your conceptual clarity from NCERT Class 11 Political Theory. Are you able to differentiate subtle definitions, elimination skills, and do you have a depth of reading beyond standard polity books? This shift shows that UPSC now expects aspirants to combine political theory plus constitutional understanding. This second example from 2021, it shows how UPSC uses simple looking questions to test deep constitutional understanding. A committed judiciary, this looks attractive but vague. An elected government, essential but not the safeguard. Centralization of powers, opposite of liberty. Only separation of powers ensures liberty. This question tests whether candidates understand the philosophical foundations of the Constitution. It also reinforces that UPSC wants students to develop constitutional reasoning and not just focus on memorization of articles or schedules. The year 2022, it marked the rise of administrative and federal questions in polity. Here, UPSC wanted to see whether candidates understood the real world functioning of schedules, not definitions, not articles, the practical impact. The fifth schedule protects tribal land. So, UPSC framed the question in terms of consequences, not text. Here, if you will observe, so option B, C, and D were meant to mislead those who rely on memory, not reasoning. This shift requires aspirants to understand governors' powers under the fifth schedule, tribal advisory councils, role of president and parliament, and also administrative autonomy. This question also shows us that why PYQs and real world understanding are now essential. Now, the 2023 polity paper, it leaned heavily towards judicial interpretations. For example, here, this question on due process. It cannot be answered by memorizing Laxmikanth. You must know the expansions under Article 21. You should know about the Menka Gandhi judgment. What is the difference between procedure established by law and due process? How did constitutional morality evolve? So, here UPSC is testing the legal reasoning, not just civics. The correct answer, principle of natural justice, comes from judicial interpretation, not constitutional text, and this shows that all the serious aspirants must integrate Supreme Court judgments, legal doctrines, constitutional case evolutions, current legal debates while studying a particular topic. And moreover, this will not just help you in prelims, this will also help you in the mains examination. We see this trend of judicial questions being asked getting intensified in 2024 also. This question seems simple, but it is actually rooted in one of the most important constitutional cases in India, KS Puttaswamy versus Union of India. So, if you will observe that right to privacy, it is not written anywhere in the Constitution. It exists only because the Supreme Court interpreted Article 21 expensively. And UPSC asks such questions to filter out the aspirants who rely only on books and ignore legal development. Again, this is a lesson for you all to include landmark case summaries, constitutional bench judgments, etc., evolving nature of fundamental rights while you are preparing for polity. This 2025 question is a perfect example of UPSC's new demand, which is authority mapping. Under the 10th schedule, the authority to decide disqualification is not the president, it is the speaker or chairman for Rajya Sabha. Statement 2 is also testing constitutional subtlety. The constitution originally did not mention the word political party. It appears only in the 10th schedule added by the 52nd amendment. Again, what you can learn as an aspirant from this question, that you need to know about the constitutional positions, amendment history, and specific decision making authorities. Here UPSC is going for an advanced level testing, so you also need to be advanced in your preparation. This question checks whether aspirants understand real federal mechanics. Statement 1 is true. The Constitution does list specific situations where the governor can act in discretion, such as 6th Schedule tribal areas. However, Statement 2 is false because the president cannot suo motu reserve a state bill. Only when the governor can reserve it for the president's consideration. Again, so from this question, you can learn that you need to focus on the center-state interactions, what discretionary power actually means, who initiates which constitutional process. This is how PYQs help you in understanding that how you have to study, what you have to study, what are the important topics, etc. This question from 2025 again proves UPSC's emphasis on real administrative functioning. Statement 1 is false. Why? The state government does not lose all its executive power. The governor gains special powers, but the state government continues to operate. Statement 2 is true. The center can assume administration of scheduled areas under certain circumstances on recommendation of the governor. So here you need to have a deeper understanding of 5th schedule, governor's special powers, center state administrative arrangements, the governance framework of the tribal area. Let me remind you or let me warn you, these type of questions cannot be answered by surface level reading. You need to have an in-depth understanding of such topics. This 2025 question is one of the deepest and most legally technical ordinance related questions we have ever seen in UPSC Prelims. It checks a candidate's understanding of the scope of Article 123, the legislative nature of an ordinance, Parliament and the equivalent powers. It also tests the ability of an ordinance to amend or repeal laws, and whether do you understand that ordinances can be retrospective. So now let's break down the statement. Statement 1 is true. So an ordinance has the same force as an act of parliament when in operation. Statement 2 is also true because Parliament can abridge fundamental rights through constitutional amendments or law under Article 33. An ordinance has equal force subject to the basic structure doctrine. Statement 3 is true. Ordinances can be given retrospective effect just like parliamentary laws. This is a wonderful example of how UPSC is now testing legal reasoning, not simple memorization. It expects clarity of powers, limits, and the nature of legislative authority. This question tests a mixture of constitutional immunity and legislative privilege, a combination that UPSC rarely asked earlier. Statement 1 is straight from Article 361. Governor is not answerable to any court for actions done in official capacity. Statement 2 also comes from Article 361. No criminal proceedings can be initiated or continued against a governor during their term. Statement 3. It reflects Article 194, Clause 2. MLAs enjoy complete immunity for speech and vote inside the legislature or its committees. What makes this question special is UPSC combined three different constitutional protection regimes into one question. This again requires a strong understanding of constitutional architecture, not isolated memorization. In 2025, UPSC asked a question that lies at the intersection of governance, economics, and federalism, the control of minor minerals. This is a brilliant example of the new UPSC pattern, not purely polity, not fully economy, but a federal functional question. Statement 1 is false. Under Section 15 of the MMDR Act, states have full authority to make rules for minor minerals. Statement 2 is true as the union government has the power to notify what constitutes minor minerals under the same act. This question, it requires not just knowing the constitution but understanding how legislation operationalizes federal power. Let us move on to the next question. So this question checks whether candidates know the precise situations under which state ratification is mandatory for a constitutional amendment. Under Article 368, Clause 2, any amendment that affects federal structure, distribution of powers, executive authority of states, union or state list, or governor related provisions requires ratification by not less than one half of the state legislatures. So, all three listed areas, union list, state executive power, and governor conditions require state ratification. This is a high level constitutional mechanics question. Now, this question on Panchayati Raj, it is an excellent example of how UPSC is playing with assumptions. Many states do not have intermediate panchayats, especially smaller ones. So, statement 1 is false. Minimum age is 21 years, not 30. So, statement 2 is also false. Governor appoints the State Finance Commission, hence, statement 3 is also false. From this, we can learn that UPSC wants us to focus on granular constitutional provisions, administrative structure, correct authority mapping, and an overall understanding of the 73rd Amendment. So, here is the evolution in a single line. From what is written to we are moving towards to how the system works. UPSC now checks if you understand administrative chains, authority hierarchy, federal working, judicial expansion, constitutional consequences, etc. Elimination is now more important than knowledge itself. Most questions between 2023 to 25 are designed so that one statement is obviously wrong, one is partly wrong, one is technical, and one is correct. Your ability to perform logical elimination will determine your score more than memorization. Now, let me demonstrate elimination using this 2025 question. Statement 1 looks official, but if you understand the 10th schedule, you know the speaker decides disqualification. So eliminate 1 immediately. Statement 2 is true. The constitution never mentioned about political parties. So answer becomes obvious once we eliminate the constitutional impossibility in statement 1. UPSC wants aspirants to who basically like understand the constitution as a living operating system, not as a static document. Therefore, your polity preparation must integrate articles, doctrines, cases, administrative structures, governance reports, ministry functioning, etc. Here is the exact roadmap to follow for the new polity pattern. Your study cycle must combine static polity with dynamic governance updates. Make sure you practice PYQs for at least 15 years, especially statement based ones. The biggest mistake that I have seen by mentoring multiple students that they make is they completely rely only on Laxmikanth. The exam has outgrown that level of preparation. Without case laws and administrative understanding, clearance is difficult. To conclude, I would say that UPSC now treats polity not as civics but as constitutional law. It expects a civil servant level understanding of governance. If you adapt your preparation to this new pattern, scoring in polity becomes far easier. So, thank you for watching. I hope this analysis helps you align your preparation with the new UPSC expectations. All the best for Prelims 2026.